Thank you, everyone, for joining us. Welcome to our webinar. My name is Jiyae Hwang. I am a senior associate at Scott Legal PC. Today, we're going to spend some time talking about the EB-2 NIW, National Interest Waiver, which is a green card pathway that allows self-petitioning for certain individuals with advanced degrees or exceptional ability. As we will discuss in more detail in today's presentation, this could be a great option for entrepreneurs. So just a few things before we get started. Scott Legal is a full-service immigration law firm, which means we do have expertise handling a wide variety of non-immigrant and immigrant visa categories suited for various circumstances. So whatever your immigration needs may be it a family matter, employment-based matter, or investment-based immigration matter, we can help you find a solution. We will be continuing this webinar series. We are doing at least 2 webinars a month on different topics. And at the end of this webinar, we will be sending out a few things to all participants. First, we will send out a copy of the PowerPoint that will be used in this webinar. We will also send you all a visa guide, a comprehensive guide to the National Interest Waiver that you can use as a reference. We will also send you a link that you can follow to sign up for any additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we encourage you to subscribe to our YouTube channel as we do regularly upload a variety of immigration law related videos. Finally, we will send you a link that you can follow to set up a consultation with one of our experienced lawyers should you wish to discuss your case further. So today we are very lucky to have Kelly Weiner, who is the managing partner of the firm with a wealth of experience handling EB-2 NIW cases, who will be sharing her insights about how you can qualify for a green card under the EB-2 NIW category. Finally, for any questions you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, I will turn it over to Kelly.
Thank you, Jiyae. So we can go to the first slide, and we're just going to talk a little bit about the National Interest Waiver requirements. So for the National Interest Waiver, there is this is in the EB-2 category, which means employment-based green card. And there is a threshold requirement of either an advanced degree, which means a U.S. master's degree or higher, or its equivalent, which would be a U.S. bachelor's degree plus 5 years of post-baccalaureate progressive work experience. If you don't have either a bachelor's and the work and the experience or a master's degree, you can also attempt to meet the threshold requirement through exceptional ability, which is defined here. Including kind of several criteria that you might be able to meet, and you have to meet at least 3 of the 7 criteria, although it's obviously helpful if you can meet more or as many as you can meet. It's good to include evidence for that. There's a 2-part test they're going to look at. So one is, have you met the plain language of the requirement? So for example, do you have letters documenting 10 years of full-time experience in your profession? And then the second part of this 2-part test is, in totality, does this mean that you're someone who has exceptional ability, who's risen above, what's normally seen within the industry? So you would want to avoid things like letters that just say, yes, this person worked for us and this was their job title. You want to include evidence that really demonstrates, not only that you meet the language of the requirement, but also that, you're someone who has kind of, risen above, what's normally seen, within the field. So once you meet this threshold requirement, then you would go on to show that you are eligible for the National Interest Waiver. So in a normal EB-2 process, you would have to go through what's called a labor certification, where you would have a U.S. employer, and they would need to test the U.S. labor market to determine if there's any willing, qualified, and available U.S. workers for the job. However, when you're doing a National Interest Waiver petition, you are essentially asking the government to waive this labor certification requirement, that you do not need to do this requirement And the reasons are, that you're eligible based on the following 3 prongs below. So the first is that you have a proposed endeavor that has both substantial merit and national importance, that you yourself are well positioned to advance the endeavor, and then that there has to be a showing on balance that it's beneficial to the U.S. to waive the requirements of a job offer and thus the requirements of the labor certification. So, we'll go into more detail in the petition about how to kind of address each of these, but generally you want to think about, when you're thinking, can I do a national interest waiver? You do have to have in mind, what is that proposed endeavor? What am I going to do? And how am I going to show it has substantial merit and national importance? Often you can look at, the White House has a list of critical and emerging technologies. There's, many different types of endeavors from, the sciences, the arts, entrepreneurship, and we'll talk about some more of those today. But it is important to think about, how will you demonstrate that what you do goes above and beyond just, well, I'm a very talented lawyer, for example, and I'm just going to run a really excellent law firm, or I have a really, I have a good business and I'm going to run that business and it will be profitable. Generally, to do the national interest waiver, it really needs to go above and beyond that to meet that criteria to show that there is substantial merit and national importance to the United States. And then second, you yourself are well positioned to advance the proposed endeavor. So you have to consider, what is your background? What is your track record? What have you, done successfully in the past? Are you able to show that you have had similar endeavors where you've been able to push these forward to accomplish the things that you say you're going to accomplish? Very important to be able to, demonstrate that about your own background. And then finally, that there has to be a showing on balance. It's beneficial to waive, why is it that, for example, if somebody says, I want my employer to hire me, because I'm really, really good at my job. Why is it that you don't need to go through the labor certification? Is what you're doing so beneficial to the United States that even if there's others doing it, it benefits for you to be doing it? If you're a really exceptional researcher, if you're somebody who's brought, new innovations to the field, if you're really changing, industry-wide practices, and increasing competitiveness, for the United States, these are the types of things that you'd really want to highlight. So we can move to the next slide. So let's talk a little bit about how the national interest waiver can be used for entrepreneurs. For many years, the test for the national interest waiver was different than the one that I just outlined. And it was a bit harder, a bit more difficult to use for entrepreneurs. But when the new case that has the new standard for the national interest waiver came into being, matter of Danazar, it was very intentional. The way that they, the language they used in the decision, and it was very intentional that they clearly intended that entrepreneurs should be able to use this category. This was a good category for entrepreneurs. And Jiyae will discuss a little bit farther into the presentation how some of the policy manual changes and updates we've seen from the government further indicate that, yes, entrepreneurs should be using this category. One thing, to flag that was very helpful for entrepreneurs is that the benefit to the U.S. interest can be local. So when we look at the prong of substantial merit and national importance, previously there was a bit more focus on kind of the scope of the geography. Will this impact be felt across the United States? And in Danazar, what they did was explain that something can have, national importance, even if it does not impact the entirety of the United States. It can still be nationally important, for example, to increase hiring and increase employment in an area with chronic, chronic unemployment or really high unemployment rates. That could be said to have national importance. So moving away from this very large geographic scope as a requirement was definitely something that was very helpful, as well as indicating that, entrepreneurs, one way they could qualify is to show that they could have many employees in an economically depressed area, that this would be one avenue they could use, to show that what they're doing has substantial merit and national importance. Another thing that was mentioned within the case is that, entrepreneurs are self-employed. And what that means is when you're going through the perm process, it's really not possible to go through that process if you are self-employed. There's a question, on the labor certification that says, do you have any ownership in the company? And if you do, especially if you're a majority owner, or you own a very large percentage of the company, or you're the sole owner, you're just really not going to practically be able to overcome this requirement that there be a bona fide job opportunity open to a U.S. worker, because the government just is not going to believe that you as the majority owner are not influencing the case such that you would not, that you would hire a U.S. worker in place of yourself. And so the case recognized really that the perm process is not set up for entrepreneurs, but that actually is beneficial for the national interest waiver argument, because you can essentially argue that, it's not possible to go through the labor certification process given these facts. And therefore, given the substantial merit and national importance of the endeavor, the fact that you cannot go through the labor certification process and that the person is well, positioned to advance the endeavor, it's beneficial to waive this labor certification requirement. And then another thing that was very helpful, I think, in matter of Danazar for entrepreneurs specifically, was that they really noted that entrepreneurial work can lead to a national interest waiver, and also importantly that the planned venture doesn't have to ultimately succeed as long as the evidence shows it's more likely than not to succeed. And what this does is really open it up more for startups. You don't have to have a company that is already successful in order to qualify for the national interest waiver. Certainly, it would be extremely helpful if you yourself as the petitioner, had done a similar type of business in the past and had a track record of success in that business. But people certainly have, and Jay will talk about this a little bit more longer in the presentation. People certainly have applied with business plans showing here's who we're going to hire, here are the metrics we're going to achieve, here's why it's reasonable to believe this is likely to succeed. And even if the venture changed or ultimately did not succeed, that doesn't mean that the national interest waiver wasn't properly granted. They can be granted based on the strength of business plans as well as the strength of the other evidence within the petition. Let me move to the next slide. Perfect. So let's talk a little bit. We'll shift away from some of the requirements and talk a little bit more about timing and considerations when, if you're here on a non-immigrant visa, which means a temporary visa, and you're moving to a national interest waiver, which is a green card, which allows you to permanently live and work in the United States and also requires that you reside in the United States primarily. So things to consider, timing. Premium processing is now available for national interest waiver applications, which is great. Previously, it was not available, and you might be waiting over a year just on your I-140 petition, or even longer. So now with the national interest waiver premium processing option, you can pay an additional fee, and they will render a decision within 45 calendar days. A decision can mean an approval, a denial, a request for evidence, or a notice of intent to deny. If you get a request for evidence or a notice of intent to deny, you would prepare supporting documentation, send that back, and then get an ultimate decision within 45 days of when they receive that response. So that is a very helpful thing, that now there's an ability to speed this up if you're not in a position to be waiting over a year. You do want to also consider, if you're in the US, what is your underlying visa status? If you're on a temporary visa that doesn't permit you to have permanent intent, so immigrant intent, for example, some examples here, the TN is not a dual intent visa. The E1, E2 has a lower standard for proving non-immigrant intent than the TN, but still you have to keep that in mind. So you want to keep in mind, like, how much longer do I have on my visa? If your TN is about to expire and you could file your I-140, but you want to keep working on the TN for now, probably you should go renew your TN and then wait a few more months before filing the I-140 petition. The reason being that if you have an I-140 filed, that is an immigrant petition. And you could certainly get an officer who says the TN requires you don't intend to be here permanently. The I-140 says, you do plan to be here permanently. we don't think there's a way to grant, this visa. There are arguments you can make. For example, if when you file your I-140, you indicate you don't plan to adjust status, you plan to get a green card at the consulate, you can certainly try to argue that your intent at this point in time is temporary, that intent should be assessed at each entry, and at this entry, your intent is temporary. But there are many officers that would have an issue with granting a 3-year visa that requires temporary intent to somebody who's already indicated they want a green card and want to live in the United States. So you do want to be discussing with your attorney, discussing with your employer, thinking about, what is my underlying status? Do I want to remain in the U.S. while I wait for my green card? Should I renew my temporary visa before I file for my green card? In terms of the application process, you submit Form I-140 with proof that you meet the EB-2 qualification. So all those qualifications we just talked about, proof that you meet that threshold requirement of your degree or exceptional ability, proof that your endeavor has substantial merit and national importance, proof of your own ability to advance the endeavor, your arguments about why it's beneficial to waive the requirement of a labor certification. If there's an immigrant visa available in the category, in the EB-2 category, you may be able to concurrently file your green card application if you're in the US in a valid status. So let's say you were here, on an E-2 visa, and when you go to file your EB-2 petition, the category is current for EB-2, which unfortunately it's not right now. So everyone, not just there's generally backlogs in some countries, for example, India and China. But as of right now, the EB-2 category is backlogged for everyone worldwide. But if there wasn't a backlog, you could go ahead and file your green card application. However, since there is a backlog at this point, what it would look like is you file the I-140, you could file it with premium processing, but you're not going to be able to proceed with the green card part of the case until a green card is available to you. And unfortunately, we do, suspect that there will continue to be delays in the EB-2 category moving forward. I think right now there's about a backlog of a year. This could increase. So definitely important to keep in mind about your underlying status if your goal is to stay if you are in the US and you want to stay in the US during this green card process. So kind of pros and cons of adjusting status versus consular processing. So adjusting status is where you file Form I-485 and you get your green card in the United States. The consular processing is where the I-140, after it gets approved, is sent to the US consulate abroad in the country where you most recently lived. So if you were living in Canada prior to moving to the US, that's where your green card case is going to be sent. And then the consulate in Montreal would process your case. You would attend an interview at that consulate. And then if your green card, was approved, you would get an immigrant visa in your passport, you would enter the US, and then your green card would be mailed to you a couple months after you enter the US. So in terms of the pros of adjusting status is if your life is here, if your family is here, the adjustment of status is usually the best way to go. You and then your spouse and any of your dependent children, so children who are under 21 and unmarried, can all file green card applications together. Along with that, you can file for work and travel authorization documents. Those are taking several months to be approved, but once they are approved, they can be renewed as much as needed until the green card is granted. So for people whose lives are primarily in the US, adjustment of status is often going to be the best option. For consular processing, if you're outside the United States and you don't have a status in the United States, then consular processing would be your only option because filing the I-140 doesn't give you any underlying status or any ability to stay in the US. It can also be a good option if you're somebody who has to travel really frequently and you're not on an H-1B or an L. For most visa categories, with the exceptions of the H-1B and L, once you file your adjustment of status, if you leave the US, you've abandoned it. So let's say you're here on an E-2 visa and the type of work you do means you have to travel constantly for business. You can't stay in the US and wait, 7, 8, 9 months to get your travel authorization. In that case, it may be better to go with consular processing, even though you're living in the United States. So it is an important thing to discuss with your attorney, particularly because once the I-140 is filed, when you're traveling in on a visa that doesn't permit dual intent, like the E-2, You just want to be prepared if there's any questions at the border. There's no prohibition against traveling with an immigrant petition outstanding, but it just, makes it a bit more likely you could be taken into secondary inspection, or you could be asked more questions about what your intent is. And you always want to be, honest about that. So just be aware of that, possible issue. But figuring out whether to adjust status or do consular processing is definitely something to discuss with your attorney, as you go through the national interest waiver process. And now I will turn it over to Jiyae to talk to us a bit about some guidelines for STEM and entrepreneurs for the national interest waiver.
All right, great. Thank you, Kelly. So yeah, let's talk a little bit about what has changed since 2022 with respect to guidelines for STEM, which stands for science, technology, engineering, and mathematics, and entrepreneurs, right? So there has been some publications by USCIS regarding updates to standards that officers would use when they're looking at STEM applications and entrepreneur applications. So the major change that we've seen for the STEM specific guidelines is the addition of the critical and emerging technologies list. And so anytime we see a client whose endeavor could be related to those advancing those critical and emerging technologies, it could be very advantageous to really emphasize that now. So there are some government publications that have been made on defining what those critical and emerging technologies are, and I can read them out to you. So, for example, those include things like advanced computing, advanced weapons technology, advanced engineering materials, advanced manufacturing, advanced sensing, so, satellite sensing or things like that. Aero engine technologies. So, for example, if your endeavor is developing like electric airplanes, things like that. Agricultural technologies, artificial intelligence, AI is also another major one. Autonomous systems, machine learning, biotechnology, communications and networking technology, including 5G, next generation wireless communication networks and things like that, data science and data storage, distributed ledger technologies, energy related technologies, medical and public health technologies, quantum science, semiconductors, and space technology. So that are some of the areas that are included in the critical and emerging technologies list. What can be very, very positive for the NIW case is if you have a PhD or a master's even in a relevant STEM area, and if your proposed endeavor is related to advancing these critical and emerging technologies, right? So advancing technologies means you typically engage in research and development in some capacity that will result in innovation or, improvement of the, general field of technology as a whole, right? So if you will be, contributing a plus alpha to the status quo on those technologies and helping the US be more competitive in those critical fields, then it could be very positive for your application because USCIS will interpret it as to be a strong positive factor for the meeting the third prong, on balance, beneficial to the United States. Now then, let's talk a little bit about entrepreneur-specific guidelines, right? So the major change that we've seen in the USCIS guidance is that entrepreneurs can now prove certain of the factors such as well-positioned or national importance or on balance with non-traditional forms of evidence, right? So we are sort of moving away from just focusing on, the traditional like publications, citations, conferences, that kind of evidence to more specific business related evidence that can show substantial merit, that can show national importance, even if the person is not in the traditional academic area. So for example, proof of incubator admission, proof of investment by venture capital firms. That can be one area, that can be one form of evidence that can support the substantial merit and national importance by showing the potential impact offered by the business project. Because if you're admitted to a prestigious incubator, if your project is admitted to a prestigious accelerator, that can serve as sort of a third-party validation of the industry disruptive potential that your project can have. So that can be very, very good for your case. In a similar vein, letters of support, expert letters from venture capital firms or leading accelerators that can also serve to bolster your case. Those letters can talk about national importance or how the particular individual is well positioned to carry out this project to fruition. Proof of having received government grants or funding for a particular project can also be a positive factor that can be considered for an entrepreneur case. Regarding well-positioned, there are some other types of evidence an entrepreneur can submit to prove well-positioned. For example, tax returns for your company that shows a history of revenue growth and proof that you have generated a high number of jobs in the United States, job creation, your W-2 records, for example, that can help prove that the entrepreneur is well positioned to continue driving forward the company's growth in the future. Similarly, contracts with relevant industry actors, contracts with leading figures in that particular industry can also prove that the applicant is well positioned to carry forward the endeavor by having negotiated and successfully garnered those contracts, and because those industry actors would have this demand for the applicant's particular work in the United States. So we'll move on to the next topic now then. So what is included typically in an NIW submission? So the first thing to note is submitting evidence that the applicant actually does meet the EB-2 threshold requirement, because that is the minimum requirement you must meet even before going to the National Interest Waiver prongs. So as Kelly mentioned before, there are two ways to meet the EB-2 threshold requirement, is either by showing that you have an advanced degree or by showing that you have exceptional ability in your field. So if you're meeting the threshold through an advanced degree, definitely include the degree, diploma, the transcript to show what kind of coursework you have done. And if it's a foreign degree, if it's not a US degree, you should get a academic equivalency evaluation report done by an accredited evaluator to prove that your foreign degree is actually equivalent to the master's or higher in the US standard. So let's say if you're meeting the advanced degree threshold through showing a bachelor's degree and 5 or more years of progressive work experience. In that case, not only do you want to submit proof of your bachelor's degree by having the degree, diploma, transcript, and the evaluation, you also want to prove that you did have 5 years of progressive work experience. And that is shown through prior letters by prior employers describing the exact dates of work, your roles, your titles, and also talking about your duties. And what is important in getting those letters to prove 5 years of progressive work experience is remembering that the work experience must be progressive. That means the duties and your responsibilities and the seniority of your position should not have stayed the same over time, but it should have increased in complexity, increased in seniority as time went on. So that would be a very important consideration when you're working with your employers to produce those letters. Now, if you're meeting the threshold through showing exceptional ability, you would want to collect evidence meeting at least 3 of the 7 criteria that we discussed before of exceptional ability. That will, as looking at the totality of the evidence, will really show that you are operating at a level that is well above what is ordinarily encountered in your field. So, for example, if you are meeting the evidentiary criteria of 10 years of full-time work experience, you would want to collect employer letters from all of those previous employers that actually do add up to 10 years. If you're submitting evidence that you have had recognition for your achievements in your field in various ways, you may want to get expert letters talking about those significant achievements, contributions to your field, and also objective evidence of your achievements, such as awards that you have won, if you have authored any patents in your field, publications, citations, all of those things you can bring in as evidence of your significant contributions if that is another one of the criteria that you're showing. So definitely it will be an exercise for you to collect the evidence responsive to those criteria to prove that you do meet this exceptional ability standard. Now, the second part of the NIW petition preparation process is to prepare evidence showing that you do meet the three-prong national interest waiver test to show that you qualify for the national interest waiver. So let's start with national importance. Typically, what you can, research are things like news articles, academic papers. Also, what is helpful usually is if you can pull government announcements regarding how the U.S. government is really interested in a part of what you're doing as a national priority. Those government reports, government announcements, executive orders can really be helpful when you're building out your case for national importance. If you are an entrepreneur and if you're trying to prove the impact of your work, a business plan will be critical because that will be one way you can show that your business has revenue generation potential, tax revenue generation potential, and U.S. hiring potential, and really describe what your contribution will be to the field as a whole, and what kind of positive, substantial impact we can see from your work. The business plan can really help contextualize that for the government. Other objective evidence to demonstrate substantial merit and national importance, that can include if you've developed a new technology before and you've published a patent for that technology, that in itself can be an evidence of innovation to the field. So you would pull the copy of the patent, you will maybe pull records of who cited the patent, things like that. Or if you have developed a particular methodology in your field, if you're a cybersecurity entrepreneur and you're really well known for doing security testing in a particular way, and you've done some presentations in conferences for that, you would pull the programs for those conferences, and really those objective evidence can show that you are being called by those industry experts to speak on that topic as someone who has unique experience and unique approach in that area. So that could also help support that your work in the United States in your field could have broader impact to support national importance. So a variety of evidences you can think about to include here. Now let's talk about expert letters. So expert letters play an important role in an NIW petition, and they can play a variety of roles, right? So some expert letters can talk about your proposed endeavor and talk about the potential impact of that proposed endeavor, and that can support really why. They can help build a narrative of why your work will not only just benefit your immediate clients, but will improve the way things are done in your industry as a whole in a broader way. Another type of expert letters can talk about your past record of success, right? So the applicant themselves, if they have done similar endeavors in the past, and if those similar previous endeavors have seen positive results that have been, talked about in the field, that has impacted the field in some way, those mini case studies, those examples can really be fleshed out through the expert letters. So the expert letters can really help support the well-positioned prong by showcasing what you have done in the past and contextualizing for the officer, like why was it important to the field. Another type of evidence we can include are, like other objective evidence relating to how the applicant is well positioned to advance the endeavor in the form of their unique knowledge, their unique experience, and the recognition that they've had in the past for their outstanding work in the field. So we would typically include the resume, any relevant degrees, proof of any professional accomplishments that can show that influence, prestigious awards won, presentations, publications, patents, all of those are relevant here in showing like what has the applicant done in the past and how has that impacted the field. Entrepreneurs. So in regards to entrepreneur applications, what we have been seeing could be helpful is, contracts, proof of contracts, letters of intent from potential investors or potential clients, and proof that you have the startup capital to show that the endeavor is likely to succeed. Contracts can be good because it can show that that there is existing demand in your work in the United States. And we would, typically include contracts with more like leading actors in the field. If for example, like, yeah, in another example, if you have, if you have agreements with potential investors that are leading institutional investors that have a track record of only investing in innovator firms, for example, we would also include that and include the, investment agreement or investment, letter of intent or, what do you call it? Those preliminary agreements, a preliminary memorandum of understanding or things like that. We would include those things as evidence that you have had traction from US actors on your idea. That can be very helpful for your case. Right, so now then let's move on to talking about a case study for entrepreneurs that can perhaps give you a sense of what a successful NIW case can look like and can maybe help you, generate some ideas about your own case. So the case study that we're going to talk about is of an entrepreneur who formed a small consulting firm in the United States, well, who proposed to form a small consulting firm in the United States to work on projects related to improving the services given to U.S. veterans and specifically returning veterans from war who may have having trouble reintegrating to, productive society, having, trouble being connected to job opportunities and things like that, right? So this person's proposal was to coordinate organizations and projects to facilitate the reintegration of the returning veterans and wounded warriors to productive society. How did this person support substantial merit and national importance? So one of the important forms of evidence that this person submitted is a detailed business plan. And in addition to the detailed business plan, this person also included expert letters from prospective clients expressing their intent to work with this particular consulting firm. And the business plan for the company really described in detail how the company's support and advocacy to U.S. veterans and wounded warriors will improve program offerings that were existing before. And partners for this, and this plan also included a list of potential partners in the United States that the applicant wanted to work with. And some of these names included various leading professional philanthropic organizations, included some government entities and some large businesses that were really buying into this idea and really expressing their interest in working with the petitioner on this project. In addition, what was also submitted was government reports, news articles, letters of support from senior officers in those philanthropic and government organizations, really describing the gaps in veterans care that was existing in the US at that time. And not only did these letters describe these gaps, these letters also described how this person's particular knowledge and this person's particular programming could improve the level of care given to these veterans. So those specific informations were critical in supporting substantial merit and national importance. Now then, let's talk about well-positioned. How did this person prove that he was well-positioned to advance the proposed endeavor? So the most important thing here was this person was not coming from a vacuum. This person had a very remarkable success record in past endeavors in the UK, where he was from. And to prove this person received expert letters from very senior officials from government who had worked with him in the past in those similar veteran welfare projects before. So some of these letters really described examples of case studies of projects that he had led, which actually led to on-the-ground success, like helping like hundreds of veterans find productive job placement and productively, mobilizing millions of dollars in charitable funding. So those specific and concrete case studies really came out through the expert letters, which helped prove that he was well positioned to advance the proposed endeavor. Finally, then let's talk about the third prong, how this person was able to support that on balance, it was beneficial to waive the requirement of the job offer and labor certification to that particular individual. And in this case, what the government really talked about was, as a self-employed entrepreneur, it was impractical for this person to get a labor certification from his own firm to go through the traditional route to a green card. Also one one argument was that the importance and urgency of the benefits that his projects can bring is so broad and so positive to the nation that it really warrants, the benefits outweigh, the ordinary benefits of having, securing a job for one other U.S. individual, which is the ordinary benefits of the labor certification process. So it was really a very compelling case to the government to approve an NIW for this particular individual because of the positive factors involved. All right, so I believe then that is it for our presentation, and we can answer the questions that have came in. All right, I can start with the first one. I have one publication, but I don't have any citations. It is okay for EB-2 NIW. Now, really depends on what your other evidence looks like, what your other credentials look like, right? We certainly have had approvals where someone has had publications with no citations. We've also had approval for someone who has one publication and one citation. Really, I would say the range, there is a wide range of profiles. And the reason why I say this is because there can be different strategies to emphasize the potential impact of your case. And if the publication is only what we're looking at, then obviously that's not going to look very compelling. But if you have other evidences from your past career that can show a broader impact and can think of creative ways to show that, then certainly I would say it is not a barrier to trying for an NIW. So definitely reach out to us and we'll help you look at your profile. Does having a petitioning employer improve chances of having an approved NIW petition, especially in the IT field? So I think this question also is very fact specific, and strategy can really come in here. I do a lot of my clients do self-petitioning, and having a petitioning employer, yeah, there could be optics concerns as well, right? Because what you're trying to prove is that your work not only benefits your immediate employer, but will have broader benefits to the field as a whole. So there could be competing considerations on how you want to choose to go about it. There is an option to have a petitioning employer, that is for sure, but there is also the option to self-petition. So definitely, yeah, reach out to us and we'll help you strategize. Do we have webinars for physicians for EB-2 NIW? That is an interesting question. We don't have a particular webinar right now for physicians. However, I have done EB-2 NIW for physicians before, and what I usually do is to focus on the broader impact to the field that the physician can have, and usually that's proven through medical research, if that is what the physician actually does. If you're just trying to work as a doctor, like that could be a more difficult case. So another question is asking what are the possible endeavors for physicians for EB-2 NIW, right? So if you are having a medical research-based endeavor, then you don't need a medical license to do that research. So there could be options that you can think about, even if you don't have a medical license there. But definitely reach out to us for a consultation so we can look at your profile more specifically.
One thing I just want to jump in there, I fully agree with Jiyae. I think also just something to keep in mind is that we're talking about the National Interest Waiver and the requirements for that. There is also something called the Physician National Interest Waiver, and that has a set of different requirements.
Right.
So it depending on what your endeavor is, like where you want, like what your years of experience are, where you want to work, where you're willing to work. The Physician National Interest Waiver requirements are quite different than kind of the general National Interest Waiver.
Right.
So this presentation is limited to the general National Interest Waiver and is not covering the specifics of the Physician National Interest Waiver. So that'd be a different category if that's something that you're interested in.
Yeah, fully agree with that as well. All right. I'm a Canadian on F1 visa, planning to apply for OPT May 2024. If I apply for NIW, does it mean I will not be able to apply for OPT? I think it should be okay. Kelly, what do you think?
Yeah, I mean, I think that it can be conflicting, right? Like it is something that is a potential concern, just given that because, OPT is through an F1 visa, which has a relatively high standard for non-immigrant intent. It's not something that we see USCIS pushing back on very significantly. And so it doesn't mean you absolutely cannot, but when you file your national interest waiver, at a bare minimum, when you there's an option on the I-140, are you going to consular process? Are you going to adjust status? You absolutely should check that you're going to consular process. If you indicate you're going to adjust status, that could be a bigger issue. And if there's any way to time it so that you are filing for OPT before you're filing, for your national interest waiver, that's generally beneficial as well. So it is something to consider. Hypothetically, yes, it could be raised on your application as, the intent's being inconsistent. There's arguments you can use to say, on this particular entry, like I still plan to consular process. My current entry is temporary, so you could apply. But it is something to keep in mind. So a good thing
Yeah.
to think about when you're thinking about the timing.
So for these types of very factual fact patterns, I would say definitely reach out to us for a consultation, because I don't think we can get a informed answer here just because we don't know all the facts. Can we show both evidence criteria for an NIW application? You need to meet all three prongs to be approved for the NIW. So substantial merit, national importance is one prong, well positioned is another prong, and then third prong is on balance. On balance, it's beneficial to the United States, and you do need to meet all three prongs. Oops. Examples for physician EB-2 NIW submission. We don't really give out examples. Yeah, go ahead, Kelly.
Yeah, and just as well, again, like I think there's a couple more questions here about the physician NIW. So that's outside the scope of this webinar.
Right. Mm-hmm.
So not something that we would be addressing here. Yeah.
Right. How quickly after getting an O1A can you apply for a green card?
Yeah, so you don't have to wait. Like there's no requirement, for example, that you get an O1A and then you wait a certain amount of time and then you apply for the green card. There's no requirement you even get an O1A at all. You could apply directly for a green card. So it just depends on whether or not your profile is elevated enough that you think you could apply for the green card. So for example, just because you qualify for an O1A, an extraordinary ability temporary visa, doesn't mean you'll necessarily qualify for the EB-1A extraordinary ability green card, because even though the regulatory language is quite similar, the standards are different. Similarly, the National Interest Waiver, completely different standards than the O1A. So I think the only thing to consider with the O1A is, again, it's non-immigrant visa with temporary, you're supposed to have temporary intent. The standard for proving that is quite low. But you may still want to wait, a few weeks, a few months before filing for a permanent visa after entering on a temporary visa that requires that temporary intent. I see someone here has asked if they can have a recorded version of this presentation. So yes, this will be sent to you and it will be available on our YouTube channel as well. It is being recorded. And somebody asked a question about L1B, again, outside the scope of this webinar, but similar answer to the O1A.
I can take this.
Yep.
So yeah, a PhD candidate working on chemistry, 2 publications, no citation yet. Well, so definitely set up a consultation and gonna send out that disclaimer. But generally, we have done petitions for recent graduates. However, there needs to be other types of evidence that strengthen the potential impact of your research. So if we have 2 publication, no citation, and that's it, then that's going to be a difficult case. But if you have other evidence, such as, if you're currently working on a research that's funded by the federal government, let's say, and what is this research about? Like, does it relate to critical technologies? Does it relate to, sustainability? What does it relate to? So it really depends on the narrative. So definitely reach out to us, and we can help you strategize on what can work for you. Master from the U.S. working in the U.S. under F1 visa. Yeah, definitely reach out to us for a consultation. We need to see your profile to see what kind of what kind of strategy can work for you. This webinar will be sent to all participants. You will receive a link to see the recorded version. DOE related work. Yeah, so we don't have a minimum citation threshold when we take a case, and we have had approvals for cases with much less citations than 100 or 150. So definitely reach out to us, and we will take a look at your profile and see what kind of proposed endeavor you're doing, and see what kind of other evidence we can come in. We can use to strengthen your argument for national importance. Definitely is not just dependent on citations. I can tell you that. Yes, similar here. Definitely reach out to us for consultation, and I can look at your CV. I can give you my impressions on that. Very difficult to understand all the facts with this content.
Yeah, there's also a question here about charges. So again, feel free to reach out to us, through email. We're happy to send you our engagement letter, which describes the fees and services.
If our application for NIW is denied, will we lose our F1 status here in the States? And the answer to that is I don't know. It won't invalidate your current F1 status. Yeah, Kelly, do you want to jump in?
Yeah, sure. So it won't. So like if you're here, you're on your F1, you're maintaining your F1 status, you're going to class, or you're on OPT or what have you. Having an immigrant petition denied does not invalidate your status. What it does mean though is, if your F1 visa expires and you want to go to another consulate to get a new F1 visa, and you're filling out, a DS-160, there's a question that asks, have you ever filed an immigrant petition? And you would then need to answer that yes and explain the circumstances. So it doesn't invalidate your current status, but could make it more difficult to obtain an F1 visa in the future if you're not able to satisfy them that you don't have immigrant intent.
Okay, so the last question is, do I need to get a master's certificate for the application, or a running PhD should be fine? You do need to get the master's certification. You already need to have the degree at the time you file in order to qualify for the advanced degree threshold.
So for questions, if someone is overstayed on a B1 or B2 visa, can you apply for a national interest waiver? So the I-140 national interest waiver, yes, you like, even if you have an overstay, potentially you can file for it. The question is, will you be able to adjust your status in the US? Will you be able to get a green card? Will you need a waiver? And the answers to that will really depend on how long is the overstay. Is there also unlawful presence? Any other, issues surrounding the overstay? So I would strongly encourage setting up a consultation so we could walk you through that process. Generally, there is a provision called 245K, which does allow for people to still file for a green card in certain employment-based categories if they haven't violated their status or worked without authorization for more than 180 days. But it's really fact-specific. And with this, not something we're able to kind of speak to in detail on, this type of forum, but happy to talk about it in detail during a consult.
Great. Well, thank you everyone for your active participation. This has been very informative. I hope this presentation was helpful to all of you. Definitely, we don't have a refund offer. Definitely reach out to us for a consultation. We'll be happy to look at your case, and we can, give you a rundown of our fees and things like that. So certainly, keep an eye out for the resources and links that we'll be sending you later. Thanks everyone for joining us, and thanks Kelly for your time.
Have a nice day.